Good morning, everyone, and thank you for joining us for our webinar, Navigating Employee Suspension Best Practices for a Fair Process. My name's Annabel, and I'm going to be hosting the webinar this morning with my colleague Victoria Ounsworth, a solicitor in our employment and immigration teams. Before we begin, I just need to quickly run through a few housekeeping points with you all. So the webinar will be half an hour long. If we experience any technical issues, please do bear with us and we'll aim to resolve these as quickly as possible. All attendees will be on mute for the duration of the webinar, so if you have any technical issues or any questions, please use the question box and we'll be able to assist you or answer your questions that way. We'll aim to answer as many questions as we can at in the Q&A session at the end of the webinar. However, if there are any questions that we don't have time to answer, then we'll follow up directly by email afterwards. Our slides for today can be found in the handout section that you'll see on your screen, and you can download these whilst the webinar is in session if this is useful. The webinar is being recorded and will be sent to all attendees later today, so don't worry if you need to jump off or if you just want to listen back at a later date, you will have a recording. And a short feedback survey will also be sent to attendees later today. So if you could take a few minutes to fill that out when convenient, that would be really appreciated. So on to the next slide then. What will we be covering today? So firstly, Victoria is going to talk to you about the situations in which suspension can arise, the contractual right to suspend and the implied right to work, and also best practices for a fair process. And then I will be discussing the employee's rights when they're suspended, the duty of trust and confidence, other risks, and then we'll finish off with a Q&A session. Please note that we won't be covering medical suspensions in today's webinar, just because it's a slightly different topic and a large topic in itself, so we won't have the ability to cover that today in the time. But that's all from me for the moment, so I'll now hand over to Victoria.
Thank you, Annabel. Good morning, everyone, and thank you so much for taking the time to attend our webinar this morning. The natural place to begin is to consider how suspension would normally arise in the first place. So in most cases, a suspension may arise where there are allegations of serious or gross misconduct, either through an ongoing disciplinary or grievance investigation, for example. Now, where serious allegations have been made, suspension will take place when the employer makes the decision to notify an employee that they are to temporarily cease carrying out work pending an investigation, for example. The need for it will very much depend on the facts, and there are lots of moving parts to consider. Now, for this reason, suspension should be considered on a case-by-case basis and should not be a knee-jerk reaction, as Annabel will consider specifically later on in this webinar. So on the slide here, we've listed some examples of where a suspension scenario may arise. So the first one, where there have been allegations of serious or gross misconduct which have been made, which would merit temporarily suspending an employee from their duties. Secondly, where as a result of those allegations, there is a potential threat to the business, other employees, or even the individual concerned. Where it would not be possible to properly investigate those allegations if an employee were to remain at work. For example, if there were concerns about destruction of evidence or any intimidation of witnesses, for example. Now, the next one ties in with the above regarding threats, but where working relationships have severely broken down to the point that there is a genuine risk to other employees, property, customers, or other business interests. Lastly, where the employee is subject of criminal proceedings, which has an impact on their ability to do the job, or where they are restricted from doing it. However, we would ordinarily suggest that specific advice is sought if there is an element of criminality, because there are lots of other things to consider in that circumstance. In some cases, it will be clearer than others that suspension is definitely appropriate. I have included an example here on the slide of a scenario in which an employer might consider suspension. So, for example, an employee has been accused of making various threats of violence to other employees and customers. The employee is suspended pending an investigation, to protect the safety of other employees and customers. Now, here it would be reasonable for an employer to consider that if the employee were to remain at work, then there may be a real risk of further harm to other employees or customers, or potentially concerns with intimidation of witnesses. Either way, employers will need to be clear of their reasons for suspension and will need to communicate that decision to the employee at the appropriate time. Equally, if the need arises, employers will need to be able to demonstrate that it had reasonable and proper cause for making the decision to suspend, and that those reasons would withstand scrutiny if it came to it. So we'll move on to the next slide then, and we'll consider the contractual right to suspend. So it's advisable for employment contracts and appropriate policies to contain express rights to suspend employees. Not only is it helpful from an enforcement perspective, which we'll consider next, but most suspension clauses, as we often refer to them, will include detail on certain arrangements that will or may apply during a period of suspension, which sometimes makes it a bit more straightforward when communicating the decision to suspend, as the employer can usually make specific reference to those contractual clauses. For example, the individual's continued right to receive their salary and benefits, that they'll remain bound by the terms of their employment contract, the requirement to be ready for contact, and any restrictions on their activities during that period of suspension. More specifically, employers can include provisions regarding the withdrawal of benefits during any period of suspension, or provisions regarding suspension of pay. However, again, these should be approached with caution, with specific advice taken in individual scenarios if needed. If there is no express right or contractual right to suspend, then an employer will need to consider whether the nature of the employee's work gives rise to an implied right to work. If so, employers should be wary of suspending, as it could be seen as a breach of contract, and Annabel will consider the consequences of this later on in the webinar. Now, generally, there is no duty on an employer to provide work for an employee. However, there are several exceptions to that rule. A right to work can be implied in several different circumstances, and we've listed some of them here on the slide, but I'll go into a bit more detail. So firstly, where an employee is deprived of the opportunity to earn commission or other remuneration, for example, where a large part of their remuneration is commission-based, they received shift premiums for working certain patterns, or where they're in regular receipt of a bonus, which is linked to performance at work, then there is likely to be an implied right to work. Secondly, their need to maintain a public profile and their need to work for that very purpose, because it becomes a reputational issue at that point. Examples could include actors or other individuals who require publicity or attract it as part of their role. And lastly, the need to exercise their professional skills frequently and need to work for that purpose. Now, that's less likely, but it does arise. Given that this right is open to interpretation and it is relatively uncertain, it is therefore safer for employers to be able to rely on express contractual provisions with regard to suspension if they exist, which in itself isn't foolproof for the reasons that we will go on to consider. Now, with this in mind, considering alternatives becomes more important. Employers should also consider whether there are any suitable alternatives, and Annabel also touches on this point in her sections, but it might be possible for employers to change shift patterns, work in a different part of the organisation, or require an employee to work from home, work at a different site, or stop doing part of their job. For example, stop using certain systems. This might be appropriate where an individual is being investigated for misappropriation of stock, for example. They then might be restricted from using certain systems as a result. So some employers' policies will make mention of any alternatives that might be available in accordance to suspension and state explicitly why they may not be appropriate in some cases. If this is the case, employers should be prepared to provide a justification in any notification letter to an employee if relevant. So we'll go on to consider the next slide, where we look at getting the process right. Now, Annabel will be discussing in more detail the potential risks of not managing suspension appropriately, but it is important to stress that getting the process right in the early stages can significantly reduce the risks later on. A failure to get the process right can render any subsequent dismissal unfair if the process was flawed. So let's look at what employers should think about with any suspension process. Firstly, make a plan, consider the alternatives. There will be some cases where employers will need to act quickly to protect other employees or business interests. However, if possible, take a step back, make a plan, consider the alternatives, and don't miss out on those important steps. If not practicable, then it's urgent. Then employers should make an appropriate record of why, so that they can later justify that decision. Suspension shouldn't be the first option. Employers will usually need to plan for the support that they'll provide to anyone being suspended. And usually, employers will need to ascertain what has happened, who is involved, how serious the matter is, before working out whether suspension is appropriate. There may be several employees involved, and it might not be appropriate to suspend them all. The need to suspend is not automatic. Employers don't have to suspend at the outset of an investigation. It might not be appropriate at that time. You can suspend later in an investigation if it becomes apparent that that is necessary. Secondly, communicate it appropriately. So express contractual provisions might not cover everything that an employee should know as part of a suspension process. So any letter to them should cover the reason why. Make it clear to them that suspension doesn't necessarily mean disciplinary action, doesn't mean that they've automatically done something wrong. Outline their pay and benefits, that suspension will be kept short and under review. Keep the facts around it confidential, and state a point of contact and any support that might be open to them during that period. Thirdly, use it fairly, keep it brief and under review. So this is a very important one. As before, suspension shouldn't be an automatic action, and it won't always be appropriate. So it should only be used where employers have cause to do so. Don't delay the investigation unnecessarily if you've got people on suspension. You know, if having interviewed most of the witnesses, it becomes increasingly clear that there's been no wrongdoing, consider returning that employee to work sooner than later. Confidentiality, very important, not only from a business perspective, but also for the individual on suspension. Pay and benefits, something that Annabel will cover later on. ACAS Code of Practice and the non-statutory guide on suspension have some very useful tips and guidance on following a fair process. If an employer does find themselves in the position of having to defend a claim, in particular an unfair dismissal claim, then it is helpful to be able to demonstrate that the employer has considered and complied where possible with that guidance. Managing a return. So periods of suspension are likely to be very difficult and incredibly anxious times for employees on the receiving end. So as soon as return to work becomes possible, it should be actioned if necessary. The longer an employee is on suspension, the higher chance it will affect their health and that it will become unreasonable to keep them suspended. Equally, when an employee does return to work, make sure they're okay, make sure they're informed and check in with them regularly. Failure to manage the return properly or at the appropriate time can lead to a breakdown in trust and in some cases can amount to a repudiatory breach of contract. Finally, review your employment contracts and policies. Do you have sufficient provisions in there regarding suspension and are they adequate? So I'm now going to pass back to Annabel, who's going to move on to consider employee rights during suspension.
Thank you, Victoria. Yes, so what's an employee entitled to receive and to have access to during suspension? Well, unless there's a clear express contractual right in the employee's contract to suspend them without pay and contractual benefits, the employee should continue to receive both of these things while suspended. And actually, even if the contract does allow for reduced or no pay during suspension, this could still be risky as it could lead to a claim for unlawful deduction of wages or unfair dismissal, because an unpaid suspension is more likely to be viewed as a disciplinary sanction and so could lead to accusations that the disciplinary process and dismissal were predetermined and unfair. If an employee is sick during suspension, they should be paid statutory or contractual sick pay, depending on what the employer does or is contractually obliged to do. But the employer should also check the employee's contract, because it could say that they're entitled to full pay during suspension, even if they're sick. An employee can take holiday during suspension if their employer agrees. Obviously, the employee wouldn't be available during this time, as they otherwise would be, to attend an investigation meeting or anything like that. And an employer can refuse or cancel the holiday if needed, giving the correct notice and following the correct provisions under the contract. But best practice would definitely be to allow the holiday to go ahead, and to be considerate of a booked or planned holiday to help demonstrate a fair process. And a suspended employee will not usually have access to the employer's electronic devices or systems. If the employer has any particular policy covering this, then this should be followed. However, there might be certain situations where it would be appropriate and even sensible to allow access. For example, if the employee needs to attend an investigation meeting, a disciplinary hearing, or if they need to liaise with their chosen companion for the hearing, if this is a work colleague. Again, this is something that would help to demonstrate a fair process. So if we move on to the next slide then, and the duty of trust and confidence. So suspension is a really serious step to take, as it can affect an employee's mental health and also their reputation, both internally and externally. Particularly for more senior employees such as directors, it can be really difficult for them to return to work after a suspension or an unexplained absence, and this can sometimes make their position untenable. And therefore, employers will need to ensure that with any suspension they carry out, they aren't breaching the implied term of the implied duty of mutual trust and confidence between an employer and an employee, as this could result in a constructive unfair dismissal claim by the employee. And as a reminder, this is where the employee would be arguing that they've been forced to resign due to a repudiatory or serious breach of contract by the employer. So what can employers do then to try and avoid breaching that duty of trust and confidence? Well, firstly, it's really important to avoid knee-jerk reactions. So employers, I think, can sometimes make a very quick decision to suspend in the middle of a grievance or disciplinary process without really considering whether they have reasonable grounds to do so. So the ACAS suspension guidance recommends that suspension should only be used where it's a reasonable way of dealing with the situation. For example, during an investigation to protect evidence, witnesses, the business, other staff, or the person being investigated, and where there are no appropriate alternatives. So with this, you'll be considering whether the suspension can be avoided altogether. And as Victoria explained earlier, there are lots of alternatives that could potentially be considered and implemented as appropriate before deciding to suspend the individual. If the suspension does go ahead, then as Victoria mentioned earlier, also you'll want to ensure that the period of suspension is as brief as possible, that it's reviewed regularly, and also that it isn't longer than any maximum time period stated in the employee's contract for a period of suspension. And you'll also want to be considering what others should be told about the suspended employee's absence, the related investigation, and their return to work, particularly for more senior employees. So I actually have a separate slide on this, which we will move on to now. Some do's and don'ts for internal and external communications regarding a suspension or an employee's absence during this time. So do keep the suspension and the investigation as confidential as possible. These things don't need to be disclosed to anyone unless this is necessary. Do discuss the communications with the suspended employee. So sometimes employers can quite understandably, as a way of keeping things confidential and vague, just sort of say, well, the employee has taken a period of sick leave, they're off sick, or they are on a special period of leave for personal reasons, but actually, depending on the particular individual, they might actually take offence to this, and particularly if they're more senior, they might feel that this is damaging to their reputation if something's being said about them that's not completely true and accurate. So it's really important to discuss communications with the employee and to agree them first before anything is sent out. And don't suggest that the suspended employee has done anything wrong, as this could prejudice the fairness of any subsequent disciplinary hearing and dismissal. And don't share any personal details concerning the employee unless this is necessary and you have their permission to do so. And so now we'll move on to the next slide and our last sort of main topic for today. So you'll see on the top of this slide some other claims that employers really need to be mindful of when suspending an employee. So unfair dismissal, not constructive unfair dismissal, but normal unfair dismissal, discrimination and damage to reputation as well. On this slide, I don't have a specific example regarding damage to reputation and what might increase the risk of these kinds of claims, because we've discussed reputational risks earlier on, particularly with directors and the most senior employees, and it's obviously these sorts of things that can cause these kinds of claims. But I just have some other examples on this slide, and actually these are all things that could breach the duty of trust and confidence as well and cause a constructive unfair dismissal claim. But there are also particular things that risks that I wanted to highlight separately, and examples that might increase the risk of an unfair dismissal and a discrimination claim potentially. So the first one, if the employer has a suspension policy or any policy at all covering suspension, then this needs to be applied consistently from one employee to another. Otherwise, there'll be an increased risk of a discrimination claim, particularly if an employee has a protected characteristic and they feel that they've been treated less favourably because of this protected characteristic and the way in which the policy has been applied to them specifically. And with the second one, Victoria's already mentioned lots of things earlier on that employees should or shouldn't do when carrying out a suspension to ensure a fair process and try and avoid an unfair dismissal claim. But I just wanted to highlight this particular example because it's quite an important one. So employees have the right to be accompanied by a trade union official or a colleague at a grievance or a disciplinary hearing, as I'm sure many of you will already know. However, there's no express right in the legislation for the employee to be in contact with their chosen companion prior to the hearing. And if this occurs, therefore, this might be contrary to the employer's instruction not to contact colleagues while suspended. And so the sensible approach here would be to allow the employee to do this, because if the employer refuses permission, there could be an argument that this would impact on the fairness of the process and any subsequent dismissal, as the employee and companion might not have had enough time to prepare for the hearing, because the companion could speak on the could want to speak on the employee's behalf during the hearing. And so this is something that can increase the risk of an unfair dismissal claim. And the last example on this slide is something that can increase the risk of both an unfair dismissal and a discrimination claim, really. So it's really important that employers look after an employee's mental health during a period of suspension. And on the next slide, if we move on to that now, I actually have a list of things here that the ACAS suspension guidance says that employers can do to prevent and manage mental health problems for an employee during a period of suspension. And so it says, communicate clearly with the employee when you tell them that they're being suspended and throughout the process. don't suggest an assumption of guilt, as Victoria was saying. Make it clear that the suspension doesn't mean that they've done anything wrong, and that you'll listen to and consider their point of view before making any decisions. And again, that's because a suspension shouldn't be a punishment in itself, and it shouldn't be as though the outcome of a disciplinary hearing has been predetermined, as this could lead to unfair dismissal claims. Keep in regular contact with the employee throughout the suspension to make sure they're okay, and also to keep them updated about the progress of the investigation and when it might be likely to end. Make sure the suspension only lasts as long as it needs to. Make sure the employee knows who they can contact if they have any concerns. And I'd also be making sure that they know who to contact for additional support as well, both internally and externally. And if that support is needed, I'd be encouraging them and really helping them to seek that support. And finally, ensure that managers have training on how to support employees with their mental health, both in these circumstances as well as generally. And there is ACAS training on mental health for managers, which can be accessed online, which might be useful. So we've now come to the end of the main areas that we wanted to cover today. We hope that you've found the content useful, and we'll now move on to a brief Q&A session. Just looking at some of the questions that we've had come through. I think we'll start off by, I'll ask Victoria a question that's come through on her section. So Victoria, we have the question, if an employee is being investigated by the police for a criminal offence, does that mean that the employer should suspend?
Yep, so it's a good question, and one that's come across quite often actually. Not necessarily, no. Employers need not automatically suspend employees purely by reason of them being under police investigation or being arrested. Again, as I said earlier, each case will likely depend on its facts, and any action will need to be in accordance with an employment contract, company policy, and still managed fairly. In the context of an arrest, suspension may be appropriate if the allegation is related to their work, if the nature of the alleged offence could cause serious damage to the business reputation, again, like we considered earlier, other employees, or as a result of their offence, they are prevented from working due to regulatory, safety reasons, or where they pose a risk to other employees. It may be that they've been released on bail, which is attached with conditions, which is naturally preventing them from attending their place of work as well. Some arrests may be entirely unrelated to their role, so won't affect their ability to do their job. If, however, the alleged crime is related to their role, so for example, say you've got an accountant, a senior financial accountant, someone like that that's been accused of fraud, then this would obviously have closer implications on an employment relationship and obviously the employer, so you'd have to take that into consideration. And again, in terms of internal investigations, they should be considered in isolation of criminal ones, and be careful not to prejudice any outcome of any internal investigation purely by virtue of there being an ongoing criminal one alongside it. I would say as well, if suspension is deemed necessary, criminal investigations can take a long time. So it's something to be mindful of if potentially an employee could be on suspension for months. It's something to keep under review and seek advice as appropriate at the time. I'm just looking, Annabel, at the other questions we've had, and I think the next one might be more appropriate for you, as it covered your section. So we've got, what would an example of a knee-jerk reaction be?
Thank you. Yeah, so well, as we mentioned earlier, a knee-jerk reaction is where an employee might have rushed into a decision to suspend without really having considered whether it's completely reasonable to do so. So an example could be, you know, an employee has been accused of making inappropriate comments to another employee, and that employee has then raised a grievance. If the employer automatically or straight away decides to suspend the employee who has made the comments without really considering, you know, whether the whether it's appropriate to do so, whether it's completely necessary, before thinking about the complexity of the situation and the seriousness of the allegations, and looking at the evidence at the outset regarding the allegations before any investigations entered into, without thinking how it might affect both employees, then that could be potentially a knee-jerk reaction with suspending, which really probably could have done with a bit more consideration.
Perfect. Yeah, it's a good point. I'm just looking again. I don't think we've actually got any more questions in the box, and it may be, I appreciate it's been quite a whistle-stop tour, so if anyone has any questions on suspension or any of the content that Annabel and I have covered, or if you subsequently watch the recording, have any questions, please do feel free to get in touch with Annabel and I. We'd be more than happy to answer any questions that you might have. But I'll hand back to Annabel to summarise.
Thank you very much, Victoria. So we just have this last slide with a couple of points on it. So firstly, some upcoming events that we have in our employment team. In early June, we have our next very popular HR networking forum, and we have a guest speaker at this one who is going to be talking about autism in the workplace. And then date to be confirmed, but in July, we're going to be having another bite-sized webinar, very similar to this one in terms of format, on grievance investigations. So please do look out for those events. Further details of them can be found on our website, and if you're signed up to our mailing lists, then you'll receive details on the events and how to register as well. Just a final reminder to complete our feedback survey. Your comments on this session today will be really useful for future sessions. So yeah, would be really grateful if you could complete that for us. And thank you very much to everyone for attending this morning.
Yeah, thank you everyone. Bye.